Everyone. I'm Sanaea. I'm Zeit's Chief Legal Officer. Many of you have probably heard me speak before, and I always get the coveted after lunch session because I think Zeit thinks that the law wakes people up, maybe? I don't know. But it might this year because we've actually had some developments. Like, you guys hear me talk about the law pretty much every year. And a lot of years I say to you, well, this case is pending, and this case is pending, and this case is pending. And in 1 or 2 years, maybe I'll have an update for you. And guess what? I have some updates for you this year. Like, there's actually cases that got rulings this year. We've actually had some changes in the law, some interesting updates, and some good things for everybody in this room. So it's positive news across the board, which means when we think about balancing innovation and regulation, there is actually more and more innovation you can do. I'm just going to help you guys with the guardrails around that, right? Where you're innovating, where do you need to maybe press pause, think about what you're doing, and maybe make slight pivots here and there. But overall, very positive news in some of the cases that we've seen come down this year. So we're going to talk about a few different things. We're going to talk about public web data, what's fair game, what's not. I know we hear a lot that it's all fair game now. It's not quite that lax, so we're going to say where are the guardrails there. Then we're going to talk a bit about copyright infringement. This is probably the area where we're seeing the most case law, the most litigation, so it's important to know what the courts are saying about this. Then we're going to talk about personal data, always a hot topic. Not a ton of changes here, but always good to know what the laws are saying. And then some rules around AI, whether you're building AI for your web scraping tools or you're building an AI product, what are some of the regulations saying there? So first we're going to talk about public web data. So we've got this innovation side, right? And this innovation list it could be 100 bullet points long, right? What you could do with public web data it's infinite, right? There is the largest data set in the world. There's so many different business use cases for this. There's so much you can do with public web data. So what are the courts saying about it? What are the regulations saying about it? I know these are very word heavy, so you guys don't need to be reading every word on these, but here's what the courts are saying. I'm going to kind of highlight some of the big topics, right? Historically, we're going to go back in time a few years. All of the web scraping case law was around the CFAA, which is the Computer Fraud and Abuse Act. It's a U.S. anti-hacking law. And so all of the litigation, people who've been around for a few years in this, remember the LinkedIn versus the HiQ case, all of that litigation had CFAA violations in it. And that was really concerning for web scrapers because not only did it carry civil penalties, which is money, but it also carried criminal penalties, which is way scarier. And so what we saw a few years ago is LinkedIn versus HiQ and the Van Buren case, which was a Supreme Court case, that came down and said, actually, scraping public web data you have lawful access to, right? Everybody can go on a public website and look at that data. You have lawful access to it. That is not a violation of the CFAA. So we kind of cleared the hacking law concerns. And those were the big concerns. But then what we saw is this uptick in cases where breach of contract became the cause of action. CFAA was put aside, and now breach of contract was the thing. So that's where, can it be a violation of the website's terms of service if you're scraping public data? And so this year, we saw the Meta versus Bright Data case where a ruling actually came down on this, right? And a lot of places you will read that the court ruled that all public web data scraping is okay. Is not what this case said. It was not that broad. Typically, case law is never that broad. They look at the facts of that case, right? But the court was very favorable to public web scraping. And they looked at what Bright Data was doing, and they said it wasn't behind a login. It was all public data. And they read the terms of service and said it does not violate Meta's terms of service. And so they had a big win there. And it was a great win for everybody in this room. And so that was kind of a good tipping point. And we're seeing that the courts are really favoring the innovation over regulation when it comes to public web data. And subsequently, pretty soon after, we saw that X settled their lawsuit with Bright Data. We don't know what that settlement said. It was confidential, but I can make an educated guess that they saw the results in the other case and they thought, hey, not worth our time. The courts are favoring innovation. So innovation winner here, okay? So really happy with that. Web scrapers should all be really happy with that. But does that mean all public web data is fair game? Is it a free-for-all now? Public web data, do what you want with it, take what you want? No. We still have some boundaries here, guys. There are still other laws we have to think about. And what you do with the data, where you get the data from, all of that still really matters. And where it matters most is copyright law. So when it comes to copyright law, this means that this is stuff like books, images, videos, any tangible piece of work that somebody created is copyrightable. If you're scraping factual data like pricing or things like that, we're not talking about that here, right? This is a creative work that somebody made. And sort of the preeminent case this year that had a big ruling was this Anthropic case. And the court made two rulings in this case, or two. One of them wasn't quite a ruling. I'm being very lawyerly when I distinguish that. But this first one was their ruling. They said, it is not a copyright violation to train your LLM with a legally obtained copyrighted work. And to break that down in sort of layman's terms, it means Anthropic paid for a bunch of books, so they legally obtained them, and then they used those books to train their LLM. And the court said that's fair use under copyright law. We're okay with that. But Anthropic also trained their LLM with pirated books. They scraped websites that had stolen those books, and then they used that to train their LLM as well. And the court said that is likely a copyright violation. So we've got two very distinct things here, right? You trained your LLM with books, that's okay. You trained your LLM with books, that's not okay. The distinction is whether you got those books lawfully or not. And so this is a really important thing for us to be mindful of, not just in the case of if you're training an LLM, but in any case. You need to be mindful of the types of websites you scrape. Just because it is public web data doesn't mean it was lawfully obtained. So there are a lot of sites out there that, gather a ton of copyrighted work in a lawful manner and have mechanisms to highlight where maybe a work was pirated and they have takedown capabilities. Those are the sites that you want to be leaning towards. You want to be mindful of the sites that have pirated works on them and just avoid them. So then we saw another case come down, bit of a pivot, bit of a different type of copyright case. This is Thomson Reuters versus Ross Intelligence. And in this case, it was a little bit different. Ross Intelligence scraped a bunch of stuff, and they then just took it, built a competitive product, and kind of copy-pasted what they had scraped. And this is sort of classic copyright infringement. So the court, not surprisingly, found that it was copyright infringement. It wasn't fair use. Ross Intelligence tried to make the argument this is fair use, but what the court said is this is a directly competitive product, and you have literally copy-pasted this other person's work. That is going to be found to be copyright infringement. However, if you're scraping from a site and then you're laying some analysis over it, you're laying some intelligence over it, and then you're producing something else, that's more likely going to go into the transformative work area. So that's where you want to be careful. You never want to be copy-pasting and developing a competitive product. That is typically going to be copyright infringement. And then lastly, we've seen a few cases come down about the outputs of a generative AI system. So Anthropic talked about the inputs, right? The court said, if you've lawfully obtained data that's copyrighted and you want to train your LLM with it, fair use, go for it. However, if your outputs are exactly the same as your inputs, that could be copyright infringement. So there's got to be some sort of transformation in your model that whatever the output is somehow different than the inputs, because otherwise the courts are leaning towards copyright infringement in those cases. And there's a ton of cases out there. There's dozens and dozens that are talking about all of these issues. But these are kinds of the big takeaways that you can have. And these takeaways can be used whether it's related to LLMs or generative AI or not. This is some good copyright principles. Make sure your data is from a legitimate website that has lawfully obtained the data. In many cases, the websites own the data themselves. That's lawfully obtained. If it's public, it's likely fair use. But you need to be careful about scraping the pirated data, the illegal content. There's a couple other lawsuits on this exact same point. And I can tell you they're probably going to go the same way as the Anthropic lawsuit. If you've gotten it illegally, there's going to be a problem as far as copyright law goes. So be mindful of that. And a lot of these lawsuits actually list what those websites are. So you could find out what the websites are specifically that you want to potentially avoid. And then, lastly, like I said, don't use it to just copy paste and build a directly competitive product. The idea of copyright law is someone else put a ton of work into something. You can't just take it and copy it and make money off of it. You have to do something to it if you want to use it. So that's kind of all of the updates in copyright law. There's nothing hugely surprising, but it's really nice to see a court making a ruling on fair use with copyrighted data. So then we go to personal data. This tends to be one I get a lot of questions about historically. So I wanted to cover it even though there aren't a ton of new developments here, right? These laws have been kind of set in place for a while. The US has a few different state laws, like CCPA. The EU famously has GDPR. These have been around for a while, and there aren't huge developments in what's happened. But to give an overview, there is a pretty big distinction between the way the US treats personal data and the way the EU treats personal data. So in the US, typically, if it's public personal data, it's kind of fair game to use. You still want to be, ethical and mindful of what you're doing with it, but public personal data in the US is typically okay. In the EU, under GDPR, there's no exception for public personal data. Everybody feels like there should be. Everybody always asks me about this. They're like, but it's public. There's no exception under GDPR. It still requires consent or legitimate interest, and you need to think about those things. And then if you're incorporating any personal data into any products, particularly around AI or things like that, you need to be mindful of some of the prohibited uses under the EU AI Act specifically, but also there are other AI laws that are kind of popping up all over the globe. Some of the big things that we're seeing are prohibited is, developing facial recognition softwares, and then things that make automated decisions kind of about your life, like employment decisions or housing decisions or loan decisions. If those are automated and you're using personal data for that, those are kind of red flags and things you need to be really, really careful of. So US, public personal data, okay. EU, not so much. And I want to add to this distinction that if you're in the US and scraping EU personal data, the EU part applies, not the US part. If you're in the US and scraping only US data, the US law applies. So you do have to think about where you are, what you're scraping, to figure out which laws actually do apply or not. And if you are scraping EU data, regardless of where you are, you need to be thinking about legitimate interest. You need to be thinking about things like data retention. How long do I keep this data? Potentially anonymization. So if you can anonymize the data, all the better. Minimization is the idea of taking as little data as you need. Don't take more than you need. Sometimes you need to provide notices to the data subjects. Opt-outs, those kinds of things. There are a whole host of things you need to start to consider if you are collecting EU personal data, regardless of where you are. So that's kind of the big changes in the law this year. And so the key takeaways are courts increasingly ruling that public web data is okay to scrape. This is probably our our biggest, happiest win for all web scrapers, but there's still boundaries, right? Ensure the data comes from a reputable, legally compliant website. It's not coming from a pirated website. That's super, super important. And while we're on that topic, we talked about the Anthropic case, and to make it a little more tangible for everybody about why it's so important, the court did tell us what the damages would be, potentially, for Anthropic scraping the pirated content. Are there any guesses about what the damages, what they would have to pay to all of these authors for scraping pirated content? And what does that come to? Does anyone know? $1.5 billion is what they offered to settle for. Way lower than what the court said the damages are. The court said the damages could be up to $1 trillion. Okay? Trillion. Like, my kids think trillion is a fake number because it's so high. Okay? There are no trillionaires in the world, but they were saying the damages could have been up to $1 trillion. And then, I think someone said 1.5 billion. Anthropic has offered to settle for 1.5 billion. So a veritable bargain, if you will, like compared to 1 trillion. So it is really, really important that you stay away from ill-gotten, illegal content. It still can be public. It still can be out there for you to scrape. It can be easy for you to scrape, but you really, really, really have to be careful of that. Don't build that directly competitive product that's just a copy-paste. Ensure you're handling personal data kind of in line with those jurisdictional requirements. And then don't use scrape data to build prohibited things like the facial recognition or the automated decision-making stuff that we talked about. Some of that might be okay, but there are very, very big hurdles to doing some of that stuff. So you need to make sure you're looking at the laws of your relevant location to make sure that it is okay to do if you are going to go down that route. And then lastly, we heard a lot today about the cool stuff you guys are building, right? There's all these co-pilots and AI agents, and it's amazing, right? Keep building the cool shit. Keep doing that. That's amazing. But one of the things the AI Act is saying, and that is, it's in the EU, but it's got a bit of that global coverage that the GDPR has, is that you need to be transparent about when you're using AI in a product. So if I'm using your product, I should know that it's using some sort of generative AI or AI within it. So it's an easy hurdle, right? You can be transparent by just saying that there's AI in your product, or that your Copilot is generating, it's a AI generated code or something like that. It's an easy hurdle, but it's an important one, and it's one they're going to be looking out for. Regulators seem to be very interested in people knowing what they're doing and what data they're getting and how they're getting it. And so just being upfront that this is, that AI is being used in a product is an important piece to that puzzle. And then lastly, I think we had someone else mention today, there are a lot of groups doing work around ethical web data. This case law, these regulations, they don't come in place in a vacuum, right? People are talking about this. People are lobbying for certain laws. People are lobbying for certain things to happen. People are writing briefs to kind of sway the courts. And so one that Zeit and a few other people that are involved in is the Ethical Web Data Collection Initiative. And what we do there is we put together ethical standards that we think should be the baseline of how all web scrapers operate. And so do try to lend your voice to that. Do try to get involved in stuff like that, because the more we have all of the web scrapers united under one front saying this is what we think should happen, the more we're going to get regulators to keep making positive decisions like we have seen this year. So don't hesitate to kind of lend your voice to that and get involved. That's it.
Thanks, Sanaea. We have time for one or two questions if anybody wants to ask some. We got a few on Slido as well.
Okay.
So the first question was how do we make sure that LLMs won't generate personal data? We can't control all the outputs.
Yeah, you can't. I mean, you can control your inputs, right? And so you need to be mindful of what inputs you are putting in. if you are scraping personal data, or even if it's not scraped data, whatever data you're putting into your LLM, if there is a ton of personal data in it, there is a chance that the outputs are going to have personal data in it too, unless I'm not technical enough to know what guardrails you would need to put in to make that not happen. But yeah, what you train with is gonna have outputs. So there is absolutely potential that it is gonna output personal data. However, if you train it in the right way, if you're following kind of the rules around personal data and data protection laws in what you put in, you're likely on the better road in what it puts out.
Thanks, that makes sense. We have another question. What will be the next legal trends in 2026?
Well, actually, I think we're going to see a ton more on copyright, because there's still at least 40 copyright cases pending, mostly related to LLMs and AI. But there's tons. At Zeit, we kind of track them all, so we do try to give updates where we can. And we are going to see more about, similar to the Anthropic case. There's a couple cases like that. There's a bunch of copyright cases from studios that relate to images and videos and things like that. So I'm hoping to see a few updates in that arena, and I think they're going to all align behind that Anthropic case. I don't think we're going to see huge shifts from where that's gone, but that's just my hypothetical prediction.
And we have somebody asking about that Anthropic case. Was this about the torrented books?
This is about the books, yeah. So this is a bunch of authors. They filed a class action against Anthropic. So this was all, all books. Some of the books, like I said, were gotten in the right way. Some books were gotten in the wrong way.
And I think we have time for questions from the floor. Marie, if you're over there, I think we've got a question down that side. Actually, let's go here first.
Just a question about Cloudflare, providing sort of a paid option for scrapers, a paid access to content. Mm-hmm. Previously, when there is no paid option, there's no other choice. Now that there is a choice, does that change the legal calculus there? You're bypassing the paid option.
I think it depends. It's a tricky one, because I think there's going to be a case-by-case basis a little bit there. But one of the things that I'm thinking when it comes to the paid option is, while Cloudflare might like the concept of a paid option, if the courts are ruling that if you legally obtain copyrighted data, that is fair use in certain circumstances, as long as it falls under those kind of fair use factors, and there are a bunch for that, I don't know that Cloudflare can change that, right? If the court is saying this is fair use, Cloudflare can put those things in place, but it's not necessarily legally binding in any way. So I'd want to look at it a little more closely on a case-by-case basis, but they're not making the law. They can make an attempt, but the courts are the ones who are saying it's fair use. And if they're saying it's fair use, I don't know that you have to follow that, right?
So then it just really is, okay, you can pay and get it easier, essentially.
Potentially, yeah.
Okay, we got another one
now,
over
if they
here.
put it behind a login or something, that's a whole different story. Yeah.
I've got a question on what defines public data just a little bit more. I mean, because there's public web data that's publicly accessible to just people who live in Italy, for example. And so there's a geo-IP block, or maybe there's public data where there's a fairly public password to get into. I don't have a specific example of that, but you have to follow some very discrete steps to get into something that is hidden but sort of in plain sight. So are there any kind of clear rules around that?
There's no legal basis for it, but if you look at some of those alliances that I was talking about, like the Ethical Web Data Coalition, ARDC, I think Sarah mentioned before too, they're kind of, everybody's sort of, all the web scraping community is aligned around public web data is something that isn't behind a login or a paywall. Anything behind a login or a paywall has a completely different set of regulations that you would have to think about and look at. So it's really anything not behind a login or a paywall would be typically what we're talking about when we say public web data.
Thank you.
Sure.
Great. I think let's finish up there. Thank you, Sanaea.
Perfect. Thanks.